Hello, my name is Mike Ryan, and the name of the show is Jury Duty and Make a Difference on BNN, the show that hopefully answers all your questions about the one-day, one-trial jury system. Our special guest today is Judge Gloria Tan from the Juvenile Court. Thank you, Judge.
Thank you for having me.
For being on the show. And Judge Tan is a graduate of Rice University and of Yale Law School, where she got her Juris Doctorate. And once she worked in the legal field, she worked as a public defender for the Council of Public Counsel Services, first in its trial unit and later in its youth advocacy project. She also served as the deputy director of the Harvard Law School's Criminal Justice Institute, where she taught and supervised adults and taught law students representing indigent adults and youths in criminal proceedings in Boston. You also chaired the Mass Bar Association's Criminal Justice Section Council and have served on the MBA Juvenile Law Section Council. And you're currently a member of the Trial Court Committee on Diversity and Cultural Competence, and Judge Tan was appointed to the bench in 2013. So today we'd like to talk about the Juvenile Court, where Judge Tan sits, and how long has the Juvenile Court existed?
Well, the first juvenile court in the United States was established in 1899 in Cook County, Illinois. And up until that point, all juvenile cases, there was not a specialized juvenile court. And then there became growing recognition around that time that juveniles are not just short adults, but rather they were individuals with special needs who were different and should be treated differently. And the goal started moving away, less focused on punishment, but rather on treating juveniles with care and treatment, and with a goal of rehabilitation. And so specialized courts, started to become established around that time. And in Massachusetts, in 1978, that's when the 7 separate trial courts were established. And so the juvenile court was created as a separate division then. Now we have a statewide system of juvenile court with 41 judges who sit in 44 different sites across the state.
So back in the olden days, kids or young adults were tried in adult court. Now they are tried in a juvenile court. Correct.
Yes. And, there's been a movement, and even as recently as, the late 60s, like in 1967, the Supreme Court found in the Galt case that actually procedural safeguards should be applied to juveniles. And, for a while, juveniles weren't even given attorneys. And even in 1971, the Supreme Court found that the same standard should be applied, beyond a reasonable doubt, should be applied to juvenile proceedings in terms of the establishing burden of proof. And up until then, it had been a lower standard of preponderance of evidence. So it's been an evolving, sort of a movement towards making sure that juveniles do have this same procedural safeguards as adults do.
What's the age range of children who come before the juvenile court?
So our jurisdiction covers children from ages 7 to 18. And in fact, September 2013, the law was passed that raised the age of our jurisdiction. Up until then, it had been from ages 7 to 17. And so, I think in recognition that juveniles, especially with sort of the more recent, I think, recognition of adolescent brain development, science has helped us sort of realize that kids, brains are growing. And so we need to recognize that. And so the age was raised to 18, which fell in line with the majority of states, actually.
Now, juvenile court proceedings are private, correct?
Yes. So aside from the youthful offender cases, all juvenile proceedings are closed to the public. So that includes juvenile court records, unlike in district or superior court or BMC, the Boston Municipal Court. Juvenile records are not accessible to the public, and I think that reflects our recognition that juveniles, the focus is on rehabilitation. We don't want to stigmatize them as criminals, and that is reflected as well in the terminology that we use. So juveniles aren't convicted; rather, they're adjudicated delinquent. they're not considered criminal proceedings. They're juvenile proceedings. And I think, again, it's just to make sure that we do respect, protect, and preserve juveniles' right to privacy.
Now, what kind of cases do you deal with in the juvenile court?
So in addition to juvenile delinquency cases where children, again, between the ages of 7 and 18 are charged with crimes, we also have our civil jurisdiction. And I believe it was 1993 that our court, the Juvenile Court, was given exclusive jurisdiction over care and protection, child welfare cases, and child requiring assistance, or what we call CRAs, which used to be called CHINS cases. And so care and protection cases involve parents who are alleged by the state, the Department of Children and Family, DCF, brings allegations that the parents are abusing or neglecting their children. And so we have jurisdiction to hear those cases, and that can result, if a court finds by preponderance of evidence that the children should not remain in their parents' homes, they can be removed temporarily. And ultimately, in some cases, the department may move to try and terminate a parent's rights to their children. And so we, in those cases, the parents do have a right to a trial, to a bench trial in front of a judge, not a jury trial. And if the court finds by clear and convincing evidence that the parent is unfit and it's in the best interest of the child to terminate that parent's rights, we do have the authority to do that.
Is the term juvenile delinquent still in common usage, and what does it mean?
Well, as I said before, and unlike adult courts, we don't say someone has been convicted. And even in my jury instructions that I give to jurors during jury trials, I always substitute, instead of saying, if you find there's enough evidence to convict, I always say to adjudicate delinquent. And so, I think that term, as I said before, reflects our mission, which is that, we're not, and it's even codified in our statute under Chapter 119, Section 53, which really states that the mission of our court, which is to treat children who come before the court not as criminals, as the law says, but rather as children in need of aid, encouragement, and guidance. And so I think that is always such a significant and important sort of mission that I always have in the back of my mind when I'm hearing cases.
What kind of jury cases come out of the juvenile court?
So we have any crime, basically.
Ages 7 to 18.
Yes, and so in some cases, I mentioned before, youthful offender cases, which are cases where the prosecutor's office has made a determination that they are going to indict kids who are at least 14 years old. And if they're indicted as youthful offenders, that means that their exposure includes any adult sentence. And those cases are reserved primarily for sort of more serious cases. There has to be certain criteria. For example, it has to be a case that either involves a child who was previously committed to DYS, the Department of Youth Services, or a firearm offense, or an offense involving the threat of or infliction of serious bodily harm.
Youthful offender cases, are they public?
They are. And they are 12-person juries, just like in the Superior Court, because the exposure, as I said, is to an adult sentence, potentially. So
in the juvenile court, you have juries of 6 and juries of 12?
Correct.
Now, when you were a lawyer, did you try many jury cases?
So I did have jury trials as an attorney, and it's very different sitting on the other side of it. But I think it's such an important right, and Massachusetts actually is lucky in the sense that, or juveniles in Massachusetts are lucky in the sense that they do have an unconditional right to a jury trial. We're only one of 10 states in the entire country that gives juveniles a right to jury trial by matter of right.
Do you explain that to youths who are accused of a crime, that they have the option to go either in front of a judge or in front of a jury?
Yes. In every case, so many of cases, I think the majority, and I don't know the statistics, most cases resolve short of trial. Either cases get dismissed or the attorneys work out a plea negotiation. And so for every juvenile or adults, for that matter, who wants to change their plea, we are required to give them what's called a colloquy, which basically is an explanation of their rights. And so I find it so important, and especially with kids, who sometimes, even with adults, when they come before the court, sometimes I say to them, I get yesed so many times during the day, do you understand? Yes, But then when you sort of dig a little deeper, they're just saying yes, but do they truly understand, the rights that they're giving up, which are really important. So I always make a point to say, you're required by law to say, you understand you're giving up your right to a trial, right? And then, of course, they say yes. And then I follow up, though, and I say, can you tell me what a jury trial is? And so the attorneys, it's funny, the attorneys who appear in front of me regularly, they know that I'm going to ask that every time, so they prepare their clients, and they come in, and their clients can usually, give an explanation. And but every now and then, when there's an attorney who doesn't appear that often, comes before me, sometimes, the juveniles can't really answer. And so I think it's really important. That's why I ask the question, because I want to know. I want to know for sure that they understand this important right that they're giving up.
Very good. So when you seat a jury, do you give any ground rules for jurors before you start a trial?
I always make sure that they, one of the first things they do when they come into the court, the venari, they are all, told to raise their right hand, and they take an oath, and that's to tell the truth, to give truthful, honest answers. And, so far in my experience, I hope that everyone's been truthful and honest. That's one thing that I always tell the jurors. And also to make sure they keep an open mind and to decide. It's really important for them to decide the case based only on the evidence that's presented in the courtroom. And so we always tell them, especially nowadays in this digital world, where you can look up anything in 2 seconds, it's important that they not do their own investigation, and don't look up, don't be the lawyer, don't be the investigator. And it's tempting, I think, for many of them to say, I'm going to look up that address, or, I'm going to look up the elements of the offense. So I always make sure that I tell them, look, you can only decide based on the facts you hear in the courtroom.
What is your role when you're doing a jury trial? What's the role of the judge?
Well, the role of the judge is to make decisions on evidence. Often, I always tell the jury, your job is to decide the facts as you hear them, and my job is to instruct you on the law as you should apply to the facts in the case when coming to a decision. And my job, in ways like a referee, if you will, to make sure, and I tell the juries this, that sometimes you're going to hear attorneys object, and don't think it's because sometimes they are trying to keep something out, but it's important that we make sure that the evidence that the jury hears is permissible and admissible under the rules of evidence. And so, we have to make decisions on evidentiary rulings.
Are you ever surprised by any jury verdicts in your experience?
Yeah, there have been a couple of times. They've gone both ways, where I thought there was a circumstantial case that I heard about a year ago in which no one actually observed the young person do the actual crime, but there was some circumstantial evidence, and I wasn't sure which way the jury would go, and they came back and found her delinquent. And again, it was a close case. Like I said, I think that could have gone either way. In my experience, I think jurors take their jobs very seriously, and they really pay attention to the evidence. And, the jury instructions, which can often take 30 minutes, and I always find when I was a lawyer, it was important for you to pay attention because you want to make sure the judge is saying everything correctly, but I can imagine to everyone else, it can be sort of, how should I say this? I don't want to say boring, but it can be a little tedious because it's important. You're talking about the law, but I look out in the jury and they're always just, wrapped in their attention, and they're really listening and paying attention. So I always find that encouraging.
Do you find a lot of your cases that are possibly scheduled for a jury trial settled just because of the presence of the jurors?
Yes, and that's what I always tell the jurors because, I think jury service, sometimes when people, realistically, right, people get the summons in the mail, and not everyone, but, I think a lot of people have sort of grown and say, I don't want to, but then I I always tell the jurors, even if we don't impanel, even if you don't get into the jury box and hear a trial, just your being there has helped us resolve the cases, because sometimes it takes, the juvenile or to see, oh, there's a jury here, do I really want to go to trial? Or sometimes it's the prosecutor, but I have to say, in my experience, I always try and go back after a trial and speak sort of more informally with the jury. I tell them I can't talk about the deliberations at all, but just to see if they have questions or find out what we can do to improve the process. And I have to say, jurors almost unanimously talk about how positive an experience it is. And
Good.
I think if you ask them, they will all say, and sometimes they do, they said they would want to do it again. And they view it as, I think one juror said she really felt like she was an important part of the process.
So even those people who might have been initially cynical about serving, you found that once they sat on the trial, they found it a positive experience.
Absolutely.
Now, you work in the juvenile court where you deal with, children and families. Do you find it a stressful job?
At times the cases can be challenging. Even today, before I came here, I heard some cases that, you're being asked to make some important decisions that really affect people's lives in a significant way. I mean, you're being asked, do I detain this young person? Do I hold them in DYS? Do I commit them? And on the civil side, do you remove a child from a parent? Do you terminate that parent's rights? And that once that's done, it's final. So they are very important decisions that you do your best with the information that you have to try and make what you hope is the best decision.
And obviously this is something, youth law has been something that you've, I shouldn't say interested, but something that you really are involved in, something you have believed in most of your career, correct?
Yes. When I was a lawyer, I represented juveniles, kids in the juvenile court, and that was always my passion, is to work with kids. And I feel that in the juvenile court, and I'll admit to being biased, I think it's one of the most important courts, because it's where most people have their first contact with the system, with the court system, and it gives you a unique opportunity to hopefully redirect a juvenile from maybe in the right direction, so that it keeps them from perhaps further future court involvement.
Now, you're a judge in the Massachusetts Trial Court. Have you gone to jury duty?
I have. I've actually been summoned twice. Once, we didn't even make it out of the room. No jury trials even impaneled. And the second time, I was also a lawyer. And I did get brought up to the side. I actually made it into the box, and I got brought up to the side and was dismissed from there. But I was a little bit disappointed when I was dismissed, because I really was looking forward to getting on the jury. Although, to be honest, I didn't know that I would feel this way. When I thought that I was getting close to being possibly impaneled, I started getting a little nervous, because it was a serious charge, and I thought, the sort of responsibility that you have as a juror in rendering a verdict, it's, an awesome responsibility. So in some ways, I guess I was a little relieved that I was dismissed, but...
Now, as part of your job, when youths are found delinquent and they've been found guilty by a jury, where are they sent?
So if we have the options of, unless it's a mandatory commitment, like if it's a firearm offense, we have the option of probation, giving a young person probation, or commitment to DYS, Department of Youth Services, which is the most serious penalty that juvenile court, if the person's not indicted as a youthful offender, can receive. And so DYS makes the decision on where the young person is going to spend their treatment time. And there's many different facilities throughout the state with different levels of security. Unlike adults, and I think not many people may be aware of this, if you're held pre-trial before you're adjudicated as an adult, the time that you do, that time you're being held, counts towards your sentence that you get if you are, in fact, convicted. But in juvenile court, it doesn't work that way. So even if you're held prior to being found delinquent, that time doesn't count towards your ultimate time that you receive after you're adjudicated, because the way our system is, the mission is treatment, right? And so DYS says, well, we can't really determine the proper appropriate treatment until after you're adjudicated. So that's one difference.
How long can someone be committed to DYS?
Until they turn 18. And that doesn't mean, so let's say if you're 14 and you get committed to DYS till you're 18, doesn't mean that you spend the next 4 years locked up. The amount of time is determined by a number of factors. There's what they call a grid, which has all the different offenses. So it depends on the type of offense. So if it's an assault and battery, it could be from 3 to 5 months. If it's an armed robbery, it could be higher, from 12 to 24 months. And DYS convenes what they call a classification meeting of treatment providers and decides, based on this young person, their history, their offense, the circumstances, this is the amount of time that that young person does. And if, let's say, they get a 3 to 5 months grid level time, at 5 months, if DYS says, hey, we don't think Johnny has really availed himself or has sort of completed his treatment, they can actually keep the young person longer.
Now, have you tried youthful offender cases?
I have not had a youthful offender trial yet.
Now, if someone is found guilty by a jury in a youthful offender case, are they sentenced similarly as an adult, like an adult?
They could be, and we have a couple of different options, sentencing options for youthful offenders. You can commit a young person to DYS to 21, or it could be it could be a straight 8 to 10 years in MCI, in state prison. It could be basically any lawful adult sentence. It could be to House of Corrections for 2.5 years. It could also be a blended sentence, a combination sentence of commitment to DYS to 21 and, let's say a 2.5 year House of Corrections sentence suspended. So we do have a lot of options when it comes to youthful offender sentencing.
How important are juries in the juvenile court?
I think they're extremely important. I think that, as I said before, we're lucky that in Massachusetts, juveniles do have the right to have a jury trial. And I think it sort of recognizes, again, that juveniles should receive the same, procedural protections as and safeguards as adults do. And to have, a case decided by a jury of your peers, I think is an important right. And, to have put the government to its burden, to prove beyond a reasonable doubt. So I think they're extremely important to juvenile cases.
And you encourage anybody, if they get called for jury duty, that they should report?
Absolutely. And as I said before, I've had so many jurors, when I talk to them afterwards, say what a great experience that they've had doing it. So I would encourage everyone to report for jury duty.
Well, we've run out of time. We'd like to thank you at home for joining us on Jury Duty, Make a Difference on BNN. Just remember, if you have any questions regarding your juris service, you can call us at 1-800-843-5879. We're also on the web as well at juryduty.majury.gov. You do make a difference. Please serve when called. It's important to all of us. Thank you, Judge Tan, and thank you at home.